everyone. We are Group 6. Our topic is corporate abuse and the lifting of the corporate veil, a legal perspective in Malaysia. Our group member have 孙连硕、曾子耿、赵嘉诚. The first is definition of corporate legal person and the principle of independent personality. A company is illegal, considered a legal person, that is, it has an independent legal identity, separated from its founders or shareholders. This means that a company can own property, sign contracts, and even share or be sued in its own name. Section 20 of the Malaysian Companies Act 2016 provides that once a company is registered, it has independent legal status. This principle was confirmed in the Farmers British case Solomon and Colleague. The court held that the company and its founders are two different individuals in law. The significance of this principle is that shareholders do not need to use their own property to bear the company's debts, and their liability is limited and only limited to their capital contribution. This also allows more people to dare to invest and promote the development of business. Second is printing the corporate with legal basis. Although the independent personality of a company can protect investors, it can sometimes be abused. Some people use companies to evade debt, hide assets, or even commit fraud. In this case, the court can take a special measure called lifting the corporate veil. That is temporarily not recognizing the independent status of the company and directly tracking down the person who controls the company behind the scenes. In the Company Act 2016, Section 591 to 595 clearly lists a variety of related provisions. For example, Section 591, the company publish false or misleading statements. Section 594, using false information to induce others to invest in the company. Section 595, transferring company assets and evading company responsibility through fraud. Once convicted, the person responsible may be sentenced to up to 10 years in prison or a fine of up to 3 million ringgit. The purpose of lifting the corporate veils is clear: to prevent people from abusing the company's identity, wielding the legal responsibilities they should bear, and maintaining business integrity and legal fairness.
I will introduce the circumstances and cases where counts left the will. First is contractual invasion. Itai was a former employee of Ford Motor and had a non-compete clause in his contract. After he resigned, he established a company and traded with Gulf's clients under the name of this company, attempting to circumvent the restrictions of the original contract. The court held that the company was a sham or cloak established by Itai to evade contractual obligations. Therefore, it allowed the will of the company to be lifted and determined that Itai was personally liable for the breach of contract. Case reference: Thailand Muhammad bin Muhammad. The Malaysian court also stated that the will of corporate structure can be pierced when there is an opposite of the company structure to evade cultural obligations. is fraud or improper conduct. There's the story. Andy controlled a company and sold the worthless mini shares under the company's name, profiting from it. The court, the court demanded that the company was established for fraudulent purpose. The company was merely a tool used by Andy to commit fraud. The court will impose the truth and hold Andy personally accountable. And there's the case. This bank, involving a series of complex transactions and improper financial practices, is ultimately re- revolved how individuals could engage in financial fraud through cooperative structures. Although not a direct cooperative case, it demonstrated the judicial principle that from cannot have substance during the subsequent trial. Next is alter ego. A spectrum is commonly completely controlled by a few individuals, and it is used to censor personal assets, liabilities, and transaction activities. The court ruled the Federal Court of Malaysia held that the company is merely a tool for the controller, and the company and the natural person should be regarded as one entity. Therefore, the lifting of the will was allowed. This case is one of the few in Malaysian company law that explicitly recognize the alter ego theory. It confirms that when the controller interferes excessively in the company's operations and abuses the company's personality, the court can consider the company and the individual as one entity. In Malaysia, the principle of corporate legal person independence is respected, but the judicial system is also increasingly embracing the prevention of the oaths of companies. In cases of illegal, f- fraudulent or evasion of obligations, leaving the company will has become an important judicial tool. It not only plays a role in civil litigation, but is also widely cited in anti-money laundering and anti-corruption field.
In Malaysia, many companies have been misusing their legal status to hide illegal activities. Some set up shell companies to hide assets or avoid taxes. Others use company structures for money laundering. There's also insider abuse, where nominee directors are used to cover up wrongdoing. This is a serious issue. It damages public trust, weakens financial transparency, and harms both creditors and investors. Under Section 20 of the Companies Act 2016, every company is treated as a separate legal person. But when this status is abused, courts may lift the corporate will to hold individuals accountable. This helps stop people from hiding behind the company to avoid legal responsibility. Now, let's look at the legal tools used to lift the will. The Companies Act 2016 gives clear support. Section 591 to 595 deal with fraud, misrepresentation, and abuse of company structure. In particular, Section 595 punishes fraudulent business conduct with up to 10 years of jail or a 3 million ringgit fine. Besides the law, courts can also use their judgment. If a company is only a cover for misconduct, judges may lift the veil. This allows them to expose the real people behind the wrongdoing. In Malaysia, we have seen these issues in major cases like 1MDB and Serba Dinamark, where corporate structures were used to commit financial fraud. These examples show why lifting the veil is so important. To deal with this problem, we suggest three things. First, SSM should have stronger powers to track the real owners of companies, also known as UBOs. Second, Section 595 should be expanded to include asset handing and abuse of power, not just fraud. Third, we need better cooperation between tax authorities, banks, and anti-money laundering agencies. In conclusion, lifting the corporate veil is not just a legal step, it is a way to stop the misuse of companies. Stronger enforcement and more transparency are needed to protect public trust and ensure companies act responsibly. Thanks for listening, Terry Makasi.